morning, Mr. Lance. Ready to proceed?
Good morning, Judge Hawks, members of the panel. It please the court, my name is Mark Zients of Miami, Florida. I represent the appellant, Martha Cabrera, in this appeal from an order of the Judge of Compensation Claims denying compensability of her December 7th, 2003 date of injury. First, I'd like to reserve 3 minutes, if I might, for rebuttal. I have a suspicion, having argued before this court, that you're aware of the facts, but very briefly, Ms. Cabrera worked for Menendez Enterprises, which is a McDonald's franchise, for about 9 to 10 years. And during the period of time she worked there, she began to have bilateral foot pain, probably about a year before she stopped working and filed this claim. She went to a doctor by the name of Cabrera, who diagnosed a rupture in the tendon in one of her foot and did surgery on it. She claimed compensability, and the defense was that she failed to prove her injury by clear and convincing evidence. That standard in 440.09.1, I believe, is applicable to what the legislature describes as exposure injuries. And one of the things that we've argued in our brief is that it's not applicable to repeated trauma, and we've cited cases indicating that the legislature certainly knows the difference between exposure and trauma, and cited areas of the law where they refer to trauma as opposed to exposure. The unfortunate thing is that there are a number of cases also cited in the brief in which opinions of this court seem to blur the line as to what is an exposure injury and what is a repeated trauma injury. Of course, it's Ms. Cabrera's position that the clear and convincing evidence standard is not applicable to repeated trauma as it would be to exposure. And therefore, the judge, having found in his order that she would have sustained, actually in his discussion of the case, that she would have sustained her burden by a preponderance of the evidence to prove her foot injuries were causally related to her work, and that they were the major contributor, or the work was the major contributing cause of the foot injuries, that the matter should be remanded to the compensation judge to enter an order finding that repeated trauma is not repeated exposure, and that she is entitled to the compensation benefits. The other reason that we raised in the first point on appeal was that
well, let me interrupt you. We're going to get up to the first point on appeal. Who has the burden of proof in this case?
Well, in every compensation case, I guess since 1990, when the presumption was repealed, it's the injured worker. Okay,
well, and I'm asking that question because the judge seemed to do two things here. Number one, he said, this doctor that's been around for 35 years, he looked at the x-rays and everything else, I accept him over the other doctor. Well, let's take him out of the picture for a second. What the JCC also seemed to say about the other doctor is he didn't look at the x-rays. He really did not know about the prior history of this person. When he was confronted with this prior history, he kind of wavered on his 70% argument. Even if that other doctor, what I mentioned originally, hadn't existed, couldn't the JCC have found that you did not meet your burden of proof because this doctor's equivocal?
Well, then the question is, what burden of proof? Clear and convincing evidence, I might have to agree with you. Preponderance of the evidence, I think the claimant might have burden, because Dr. Goitman, who I pointed out in my brief, was not the most articulate of witnesses who spoke. Again, difficult to understand what he was actually trying to get across, but I think the end result was that when he was faced with all the other possibilities, the end result was he said, no, this is still a 70-30 related to the employment situation. The underlying condition was aggravated or accelerated, but certainly standing on your feet, walking 9 to 10 hours a day, 5 to 6 days a week, is the competent producing cause, major contributing cause of this injury.
I'm getting back to more of a legal question. I understand what you're saying, but as I read your first issue, and I may be wrong, I don't have it in front of me right now. It talked about having competent substantial evidence to support the JCC's decision. And I guess my question goes down to, when you're ruling against the party that has the burden of proof, do you have to demonstrate competent substantial evidence to support that decision, or can the JCC just find that the doctor is not credible?
Well, it becomes a really semantic problem. As I read the cases, the record has to show that there is competent substantial evidence of a lack of clear and convincing evidence.
Okay. I don't think you're wrong. The case law seems to indicate that, but I have trouble trying to grasp that.
I know it's a very difficult concept, which is why I said in my brief, all the evidence came in by deposition. The court's going to have to look at the medical evidence to determine whether or not there is competent substantial evidence to support the judge's finding that there was not clear and convincing evidence, which is what he found. If you have to read the depositions for that purpose, you can read the depositions for the purpose of deciding the facts in the case, because you're in as good a position as the trial judge with deposition testimony.
Okay, a lot of that case law came out that we're in just as good a position as the trial judge a long time. It's a little bit older case law.
So I'm a bit older lawyer.
Yeah, I'm getting there too. You know, it's January 1st, I'm the longest serving judge in the court. I'm really starting to feel old.
Well, as of March, I collect my first Social Security check.
But I guess what I'm getting at is, what's always kind of concerned me about that case law, aren't you putting us in the position of a fact finder? What deference do we have to give to the JCC, who's the expert in the area, when there's only depositions introduced?
Well, I don't think any of the draconian changes that the legislature has made to our statute has eliminated the authority of the court to look at deposition testimony and to evaluate it in the same shoes as the judge of compensation claims. Because if the judge makes a mistake as to the weight of the evidence, which is really the burden of proof situation in this case, the only way to rectify that is to say to the judge, you've interpreted the evidence wrong. Now, Dr. Kashik, whom the judge relied upon, in cross-examination, reading from the record at page 292, but to say one is 45% and the other were 55% or vice versa, it's that close, and they are almost equal contributing factors. So he didn't really provide competent, substantial evidence that there was no clear and convincing evidence from Dr. Goitman, or, as it turns out, Dr. Agrabaya's opinion got in there. He agreed with Goitman that it was 70-30 related to the work. Dr. Kashik, as you said, Judge Wolf, could be a non-entity here. Dr. Goitman, if I went back and read his testimony, said that without somebody presenting to me factors showing that this lady ran marathons, or that she spent an equal time on her feet at home versus at work, or that there was some other factor that he wasn't aware of, not the fact that she had this kinder cap deformity in her foot. Both doctors agreed that that was subject to aggravation by the type of work she did or the type of shoes she wore. But the underlying basis for the judge's finding that the claimant may have proved your case by a preponderance of the evidence, but not clear and convincing evidence, leaves it up to you to determine is there competent, substantial evidence to support that finding. And we don't think there is if you evaluate the testimony.
Can I go to your third issue for a second? And I guess it comes down to me, is this the appropriate form? Because how do we know that if you go to circuit court and file a tort claim, that the circuit court might not rule along with the Oregon case? I mean, the Oregon case is a substantial cause and doesn't reach major contributing cause. It's not covered by the workers' comp statute, therefore the workers' comp immunity does not apply. I understand that whole argument, but the question comes down, is this the appropriate form, or if you lose here, is the appropriate form for you to go to circuit court and try to file a tort action?
Well, there's a great deal of controversy over election of remedies. If we lose here and the end result is you did not have a workers' comp remedy, so you could not have elected one, then we can go to the circuit court. Unfortunately, there may be a statute of limitations problem with a December 2003 date of accident, but that brings me to...
Well, and also the judge is finding that it was preponderance, but not clear and convincing. Does that hurt you in the circuit court?
I don't think so.
In other words, he says this is a workers' comp case. It's just a remedy is not available to you. Just like when you miss 3 days of work because of your injury, you're not going to get any lost wages. I mean, you clearly have missed the work, but there is no benefit for that particular loss under the workers' comp statute.
I think then you have to analyze the footnote 4 in Martinez v. Scanlon, which basically said if your claim used to be compensable, but now because of changes in the compensation law it's no longer compensable, you still have your tort remedy. I think that fits into that language. You also have the opinions of
well,
this
I mean,
court.
eventually, there has to be a line. I mean, you know, clearly, when I give you 2/3 of your salary as lost wages, and there's a third that's missing, I mean, you can't go to circuit court and get that, correct?
Now you're getting into an area which is presently pending before the circuit courts and Third District Court of Appeals, and that is, since the current law offers no compensation whatsoever for partial disability, my answer is yes, you can go to the circuit court for your loss of wage earning capacity if it's not total, and that's the position I'm taking in the circuit courts below.
Okay, it seems to me there are two issues rolled into one here. Number one, can you go to circuit court and workers' comp immunity doesn't apply? Or the question of whether the workers' comp statute is now unconstitutional. And I guess on the workers' comp statute being unconstitutional, can we look at a specific claim, or hasn't the law said you look at the totality of all claims, that this is an adequate substitute based on all the remedies that are provided? Just because one person may be out the window doesn't mean the statute's unconstitutional. You have to take the whole system into balance.
Well, again, in the remaining 14 seconds I have, I don't think I should respond to that question, but my personal beliefs are that the statute became unconstitutional when Florida changed from being a contributory negligence state to a comparative negligence state with no additional benefits for injured workers. And providing an alternative remedy that used to take the place of the contributory negligence standard in the circuit courts, now comparative negligence, the remedy had to be much better. And instead, it's gotten, as you all know, substantially worse. I'll reserve the rest of my time.
Thank you.
Hi, good morning. Kristen Tajak with Conroy Sinberg on behalf of the appellees. This is an appeal from a final merits order where the JCC found that Ms. Cabrera failed to establish by clear and convincing evidence that her employment was a major contributing cause of her injuries.
Is there a difference between repetitive trauma and repetitive exposure?
Well, I know that the appellant has taken that position. However, the injury at issue in this case is clearly an exposure type injury. Her claim is based strictly upon her repeated standing and walking around at the McDonald's restaurant for extended periods of time.
But don't you think, I mean, is there a difference between perhaps being in a sick building and being exposed to mold day in and day out and developing some kind of medical condition as a consequence, versus typing on a keyboard and developing a problem in your wrist, where these are little traumas. The walking around McDonald's are little traumas, but just sitting in the building would be an exposure. Is there a difference in that, or are they both traumas? Or both exposures?
I think they're both exposures, and I think that's the issue, that this is an exposure case where she was repeatedly exposed to the same circumstances that she's claiming had caused her injuries in this case. But she's failed to meet her burden of presenting clear and convincing evidence to demonstrate that exposure was a major.
You can see there are repetitive trauma cases versus repetitive exposure cases.
I'm sorry?
is there a difference? Is there repeated exposure cases and are there repeated trauma cases?
Well, I saw the cases concerning the trauma, but again, I think that they're the same circumstances, repeated exposure to the same, conditions over an extended period of time. And
well, my hypothetical on the mold, there would be nothing that the employee could do, may not even know it exists, whereas the carpal tunnel, we can put them in a proper chair, we can avoid those consequences frequently. Does that make a difference? I mean, is your position that all repetitive exposure claims are in fact just another term for repetitive trauma? That they're really one and the same, and it's clear and convincing evidence of the burden of proof? Yeah,
that's correct. And the statute 440.09, clearly evidences that that it was the intent of the legislature to have a clear and convincing standard in these type of cases. And on review, the appellate court is not, the function is not to reweigh the evidence that was presented to the JCC, but rather it's somewhat of a lower standard that there has to be competent substantial evidence in the record to support the JCC's finding that there was no clear and convincing evidence. And
so even if we could, or evaluate the evidence in the same position that the JCCs could, it's not our job.
That's correct. I mean, in McKesson Drug Company versus Williams, which was an exposure case, the court stated that the appellate court's function is not to conduct a de novo proceeding, to reweigh the evidence to determine whether the evidence as a whole satisfies the clear and convincing standard, but instead is to determine whether there's competent substantial evidence in the record to support the finding. And here, the evidence demonstrates that Ms. Cabrera failed to meet her burden. The evidence presented from Dr. Kasha, while the JCC took the testimony of Dr. Kasha over Dr. Goikman's testimony, even if we were looking strictly at Dr. Goikman's testimony, which was the claimant's IME doctor, the testimony itself is insufficient to meet the clear and convincing standard. Dr. Goikman was unable to testify to any degree of reasonable certainty that the employment was a major contributing cause, and ultimately on cross-examination agreed that it was a 50-50 causation ratio. And Dr. Goikman also testified that her obesity and congenital deformities, from a medical standpoint, would be enough to preclude her from proving by clear and convincing evidence that her employment was the major contributing cause. And that's at pages 102 to 103 in the first volume of the record. Therefore, even if Dr. Goikman's testimony is reviewed for its sufficiency, the court should affirm the JCC's finding that Ms. Cabrera's injuries were not compensable because she failed to meet her burden.
Does she have a circuit court remedy? I mean, clearly, I think the doctor has testified that with her foot deformity, standing at McDonald's every day for work for 9 years aggravated the condition. Does she have a circuit court remedy?
I'm not really sure what the basis of her claim would be against the employer in this case, but I think that the very nature of this case supports the legislature's decision to raise the standard to clear and convincing. This is a case where she was working at a McDonald's restaurant and was on her feet all day and is claiming that this was the cause of injuries to her feet. And the evidence demonstrates that there were additional causes that predisposed her to the condition, and she's failed to meet her burden.
What if the JCC had said, I find the fact that she stood on her feet for all these times was 49% responsible for her injuries? Under the workers' comp law, this person would not have a remedy. Is that correct?
That's correct. She would.
Why shouldn't they be able to go to circuit court and say McDonald's is 49% responsible for my injuries. They should pay for it. They should have been providing me chairs, they should have been providing me breaks, and they were negligent in doing that. Why shouldn't they have a remedy in circuit court?
Well, I don't really see why she shouldn't. I mean, if she has no remedy under the workers' comp statute, then...
I mean, is there a difference between something not being covered in workers' comp and something being external to workers' comp? I mean, clearly, you know, the court, we've held that if the employer willfully injures your client, then they can go to circuit court and they have their full circuit court remedy. But that's not covered under workers' comp. But there's many, I mean, workers' comp never makes you whole. I mean, you trade off being made whole for certainty of some benefits, right? Mm-hmm. I mean, so there's lots of things that aren't covered under workers' comp.
Yes, that's correct. I agree. But, I mean, I think that the issue on appeal is merely whether the JCC's conclusion...
Who are you representing here?
I'm sorry?
Who are you representing here?
The appellees.
Who are the appellees? The
employer, Carrier.
I'm just wondering whether the employer, Carrier, would be real happy with you saying that these people probably might have a circuit court remedy.
Well, I mean, I'm just saying that, you know, whether... I don't really think that that's the issue that's been raised on appeal. And I think the issue here is whether the JCC's ruling was correct based upon the evidence that was presented. And the record clearly demonstrates that there's competent, substantial evidence to support the JCC's ruling.
On this record, if the JCC had found and awarded her benefits, you know, found that magical, clear, and convincing, whatever percentage that is, would you have grounds to appeal? Would this record support a finding by the JCC of compensability?
No, I don't think that the record does support a finding of compensability.
So this isn't one of those cases where the JCC could have said, yes, I'm persuaded and be affirmed, or no, I'm not persuaded and be affirmed? No,
it's not. And in fact, you know, the appellant has conceded here that based upon the testimony of Dr. Goikman that she presented in support of her claim, the clear and convincing standard was not met.
But that's because we're looking at what the JCC found. The JCC, I mean, that's who has to find it. I mean,
right.
You don't think the JCC could have found it?
Clear and convincing evidence that this employment was a major contributing cause of her injuries. I don't. Not based upon the
I mean, he found it was preponderance, right?
I'm sorry?
He found preponderance. I mean, he said if it was the old standard before clear and convincing, he would have...
Correct. But under the statute, the standard is clearly clear and convincing evidence to support causation and employment as a cause, a major contributing cause under the statute, and she's clearly failed to meet her burden. Thank you.
Mr. Lyons, your rebuttal?
Thank you, Judge. I think when we go back in time and talk about repetitive trauma and repetitive exposure, the carpet installer knee kicker case comes to mind. That's where every kick of the knee was another trauma. Just as Judge Hawks pointed out, all the walking and standing was repeatedly traumatizing to a minute extent to this claimant's feet. The exposure case we think of is the exposure to the open oven. I think that's Sezikal versus Chrome roofing, which is not cited in the brief, but that's where the person was looking into the oven and developed the cataracts, and that's an exposure to a condition, exposure to mold. I think that it's not easy to draw the line, because some things can be both.
I'm sorry, do any of those exposure cases use the term repetitive exposure?
Yes, one of them. I think we cited in the brief, Troche versus Geico, the court discusses exposure to trauma. That's the language from that case, Troche versus Geico. So it certainly is confusing, but I think we've also pointed out in the brief that the legislature knew to talk about trauma when they talked about mental injuries. So if they meant trauma, they could have put trauma, repeated trauma, and exposure in 440.091 and made it clear what the standard was for both. They only put exposure, and they give examples of exposure cases, the mold exposure, but they didn't give examples of trauma cases. So I think that the plain meaning of the statute would not apply here, and that's basically the least intrusive way of deciding this case. If you get to constitutional standards of approval, the legislature could have put in beyond a reasonable doubt if they wanted to, but that wouldn't make it constitutional in a corpus type setting.
If we bought that argument, if we were persuaded that that was the correct argument, do we remand for the JCC to make findings, or do we just remand for entry of judgment in your favor?
I think because of the JCC's comments about the preponderance of the evidence and that the record has competent substantial evidence to support those findings, that it would just be for entry of an order consistent with a preponderance of the evidence finding applicable to repeated trauma as opposed to exposure. And last, Judge Fox, you were commenting on the circuit court, and I remember reading Vigliotti versus Kmart, which was cited in the brief, and it appeared that Kmart wanted to go to circuit court on those arising out of cases. So they were pushing for the most narrow definition of arising out of, and this court wouldn't let them, and the third district wouldn't let Publix do the same thing. They said, no, we're not going to put you in circuit court. We want to find these things compensable. So I'd ask you to reverse. Thank you.
Thank you, Counsel. That concludes this morning's docket, and